Hello, everybody. Hello, sweet, perfect baby girl, Ava. Oh, she was laying down on the big bed. I interrupted nap time, but it's okay because I interrupted it for treats. For her blue buffalo treats. Her most favorite thing in the world. Next to Mama, of course. She says, yeah, right. Blue buffalo, then Mama. We're getting down to crumbs in that bag. That bag's I think it's got one full bar, and then the crumbs go, yep. One full bar, and then the crumbs go in the dish. Hello, Nana Laura. Hello, Manuel. Hello, C-Rex, my love. Hello, Buzzy Pug. How you doing, sweetie? And then you get your bonus treat since we get down to the bag of the end of the bag. We go by bartender rules around here, you know. When you empty the bottle with the last shot, then that's the free one. She's like, what? What? Wait a minute. I counted 3. Hello, Jared Matthew Boyd. Oh my goodness. Congratulations. I'm glad things are looking up. I hope you're feeling better. Hello, Charlie. Hi, Auntie M. Hello, Epiphonium. Hello, Casey Battles, my love. I'm so happy you're here. I've got a lot of good stuff pulled out. The stuff that I was going to run last night, and then last night never came because I realized I had my deposition today, or I guess not deposition, but the where you meet with your lawyer and prepare for your deposition. Yeah, I can't talk a whole lot about it because it's the ongoing case with my car accident, but tomorrow's my official depo. I'm not excited about it. I'm not worried about it though. The only thing that I'm worried about is it means I have to get my van cleared off so that I can actually drive to it. That's the only thing I'm really thinking of. Yeah, the van hasn't been cleaned off since that big snowstorm. It hasn't moved. I don't drive much for very obvious reasons. So I'm not looking forward to it. I was hoping today would be warm enough to melt it all off. It wasn't. It certainly wasn't. Oh, honey. I love you so much. The truth is, you guys are the real stars. All I do is hit play. You guys are the funny ones. You guys are the ones that make me laugh all day. You make me happy. You make Ava happy and the cats. You guys are the real great ones. I think I do get a discount for not driving very much. I was getting one for my daughter having all A's, but then she stopped showing me her report cards. She's still getting all A's. She just, doesn't print them out for me to send them along. Sorry, I got a crooked nail here that's getting caught on stuff. What the heck? There we go. Hate that little prickly nail. I'm sorry. Hello, Squishy. I have to go to bed early tonight. I have to be up in the morning, and I'm not going to get to download any court, so I'm going to need your help getting Kansas. Because there's a couple of FTC cases that I have tomorrow that I can't get. So please, please watch Kansas for me and get it for me because I can't. I won't be here at all. Hello, Mortimer Duke. Yeah, I wish I was getting some Z's. I actually got 11 hours last night. I went to bed I went to bed very shortly after 11. And then I woke up at 10:37. So it was I got up a couple of times, to pee and take the dog out. So I mean, it wasn't a straight 12 hours or 11 and a half. It was broken up with a couple of little pauses, sort of. I know, which is why I'm putting it on you. Oh, I know so many of you would. I know it. It'll be okay. I think my neighbors might take issue with that. Just a little. I'll just say that I'm marking my territory. I mean, the cats and the squirrels and the dog, they already do it already. Nobody even knows I exist in the animal world. A wee bit. Just a wee bit. Pun intended. Yep, I did. I went straight to sleep. I zonked it. There was that little bit of me that was like, okay, I'll get one video set up for morning. And then the bigger part of me went, no, you won't. I wrote down an idea that I had for a meme. I wrote it down because I knew I wouldn't remember it. And then today I'm heating up some leftover chicken soup and I look down and I'm like, oh yeah, I thought of that right before bed. I love that. I love that. I don't remember anything like 15 minutes before I fall asleep. If I get to that overtired point that I've been at lately, yeah. Yeah, you get the greatest ideas right before you fall asleep and then you don't remember them the next day. So I now will write them down. I will force myself even to just, hang the pen over the side of the desk and just be like thought this. And then I'll figure it out. It'll come back to me once I see the note. So yeah, so I figured since I have to go to bed even earlier tonight, I figured I would come on here and spend a few hours with you guys. And then I will take more pain medication and go out and work on the van, getting it cleared off and ready to drive on out of here. Maybe even fire it up to make sure that the battery even still works on it because it's been so dang cold. So, asleep, in the shower, or going to the bathroom. Those are the three main times. I swear. That's for some reason your brain just starts firing all those happy electrodes and you come up with the best stuff. There is actually a scientific reasoning for why you have really insightful and inspirational type thoughts right before sleep. I don't remember what the explanation was, but there is science behind it, that it is a real thing. It happens to everyone. That I guess it's something to do with your brain is like clearing out all of the thoughts of the day and stuff, and I don't know. It's there's logic and science behind it. All I know is it happens, and I come up with some great stuff. You wouldn't believe how many amazing, wonderful ideas I've not remembered. All I know is I had them. I just can't remember what they were. Yeah, you wouldn't believe how many. Because I don't know how many, because I've forgotten most of them. All right. So you guys remember, you remember this gal? Not not this one. Not this one. She's crazy and you see her all the time. But the one next to her. Remember that lady? Zanny Joanne? She has her own playlist here. Yeah. Well, when I was finishing up editing, I just happened to see a warrant to show cause docket with Zanny Joanne. Ah, she's back. She's back in our lives. And that's hilarious because the last episode that I did with her, I had I had put on there the to be continued with a question mark. Yeah, it's not the last time. It's not the last time for us to see Zanny Joanne. She's back. She always used to appear at the heel of the docket because she would come in late and slowed it down tremendously. So we have a new episode to add to the Zanny Joanne saga. I put her up first since she's an update, and then we'll go into Judge Ulrich, and then Judge DeSanto, and back to Magistrate Ulrich. Yeah, we're gonna see some good stuff today. Billy, you are on a diet. You don't need more treats. Stop it. Narrator's voice. He did indeed not stop it.
entitled State of Kansas versus Joanna L. Carson. Case number 2024 CR 14. Joanna Carson appears from the Greenwood County Jail Zoom location. Chris Ambrose appears as defense counsel. Jill Gillette on behalf of the state of Kansas. This matter comes before the court at this time for hearing on a warrant to show cause alleging probation violation, referring to an August 19 arrest for various charges. Apparently, there was an earlier order that she was instructed to contact her ISO every Monday until her case had been transferred to the 11th Judicial District, but apparently those contacts had not been made. There's an allegation that she was in possession of methamphetamine in August of 2025, and then has failed to continue in the Senate Bill 123 treatment program that she was placed in. Mr. Ambrose, what are your client's intentions regarding these allegations?
The Senate 123 bill was the only thing that saved her hind end the last time. It's the only reason she's not in prison.
Your Honor, there's been discussions between the defendant and the state in which Ms. Carson's prepared to enter a no contest statement to the underlying violations, and then I believe the state's going to be recommending that she serve a sanction and be placed back on probation, get back to doing what she's supposed to be doing with treatment and all that.
Ms. Carson, you've heard what your attorneys announced on your behalf, that you would waive any due process hearing that you'd otherwise be entitled to, where the state would have the obligation of proving these allegations by a preponderance of the evidence. This is evidence that you could challenge with your own evidence, with the assistance of your lawyer, confront their witnesses unless good cause was shown. And among other lesser remedies, Ms. Carson, the court could have you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, sir, I do.
And do you waive a hearing in this case and stipulate and agree that you committed these violations, which the court outlined earlier?
I do.
All right. Court finds that the defendant has knowingly waived her hearing in the case, stipulates and agrees that she's committed the violations that was referred to by the court earlier. Court does find that these are substantial and material violations of the terms and conditions of Joanna Carson's probation in the case. This time, the court will take recommendations regarding an appropriate disposition in the Carson case, starting with Jill Gillette on behalf of the state.
Your Honor, Ms. Carson has stipulated our recommendations are going to, and I've visited with Mr. Ketley. He sent me an email. We talked. His recommendation is that she hasn't had any intermediate sanction. This is her first time up. She did do the inpatient treatment at Cherry Creek Treatment Center in Wichita, but she didn't do her outpatient. He wants her to start into her outpatient, have a 3-day sanction. Upon discharge, she will need to get into that outpatient treatment and continue to do it as recommended on her discharge from inpatient treatment. And the recommended sanction is 3 days.
Very well. Mr. Ambrose, your recommendation to the court?
Judge, we're joining in that state's recommendation. I will let the court know that Ms. Carson has served more than 3 days at this point since she's been picked up on this warrant. So if the court deems it appropriate to grant her credit for the time that she served in custody awaiting this hearing, she will have extinguished that obligation, just so the court's aware. We'll let the court know that I think that Ms. Carson's plan in speaking with her is that in addition to getting back into the outpatient treatment track that she needs to, I think the plan is she's going to get a fresh eval done, and then whatever the heck they recommend she's going to be doing is what she wants to do, which seems appropriate here since we've had the intervening legal issues that have arisen since she did complete inpatient treatment. So some possibly examining some more intensive treatment options might be a good thing for her.
How much are your fees in the representation of this client in this go-round, Mr. Ambrose?
Judge, give me 1 second here. we've had a real quick turnaround on this case from my appointment to being here. I anticipate to have, we'll be right at $200. I met with her yesterday to go over some things. Ms. Gillette and I sent a couple emails back and forth, or a quick phone call, I can't remember. And then we'll have this hearing today. So there's not much to it. This one's been such a quick turnaround and relatively straightforward.
Yeah, all the communications pretty much went. Yeah, did your client Violet? Yeah, she did. All right, well, let's start her on the 3-day dip, and next it'll be a dunk. Okay, sounds good to me. And that's pretty much how it goes in Kansas.
You know anything about your client's current financial resources?
No, Your Honor, but I have no objection to the court inquiring directly as to that.
Ms. Carson, how
Yes.
do you financially survive these days?
I'm on disability. I get roughly $1,200 a month.
Okay. Do you still own your case?
Yes, and I plan to get payments going and get started on it when I get out too.
Okay. How much per month do you think you can pay on your case?
I know last time when we was in court, you guys wanted me to pay $50 a month, but I'll try to pay at least $75 a month.
All right. Very well. Is there any further statement that you wish to make in mitigation of punishment or anything further, Ms. Carson, that you would like to present?
No, sir, there isn't.
All right, Ms. Carson, I think you have to make a decision about whether you want to remain on probation and do the treatment, or if you just soon do your time. I mean, those are your options, really. Successfully complete the rehabilitation component of your probation, or just essentially volunteer just to serve the time out. That would seem like a waste of your time to be just simply locked up, directionless.
Right.
This court, at this time, for a sanction for noncompliance, will order a 3-day dip sanction. That will run prospectively, not retroactively. The defendant will be awarded jail time credit for what she's previously served against the aggregate of her sentence, but this dip is intended to be prospective. 72 hours from now, the court will order her released back on community corrections. Any previously established condition which hasn't been met will need to be met, including her quick re-entry into an approved outpatient treatment program, which followed her inpatient treatment completion that she had done earlier. Apparently that's recommended by the provider and deemed to be in her best interest as far as rehabilitation is concerned. Ms. Carson, you really haven't got involved in that outpatient treatment component. It may take some time to complete. I do note there is some time left in your original probation period. Apparently it was an 18-month probation starting January of 2025, which would take you into July of 2026. The court will just simply announce that her probation remains in effect, and she's on probation until July 23 of 2026. Court's going to waive any additional fee assessment in this case. Ms. Carson really needs to get paying on what she already owes. I'm not inclined to add additional amounts at this point. Further going to order as a condition of reinstatement that Joanna Carson call the Community Corrections Department on Monday of next week. That date is December the 8th. Obviously ask for Mr. Ketley, but you'll need to talk to somebody about future reporting to that or another office that they authorize. All right. Is there anything else that the court needs to address at this time from your perspective, Ms. Gillette?
I don't believe so, Your Honor. Thank you.
Mr. Ambrose?
Nothing further, Judge. Thank you.
Ms. Carson, do you have any questions about the court's orders?
I don't, thank
All
you.
right. You should be released on Sunday at about this time after serving 72 consecutive hours in the Greenwood County Jail as a sanction for noncompliance. We call it a 3-day dip sanction. And then make that call to Community Corrections on Monday. Ms.
I will.
Carson. Okay. All right. If there's nothing further, then the Joanna Carson matter will currently be in recess. This meeting may be ended for all this time.
Thank you, Judge.
Thank you.
Yeah, she needs to just serve out her time. The thing is she won't. She will never voluntarily serve out her time because she would lose her disability benefits in that time. So she's going to continue on this 3-day dip here. Oh, I want to do treatment, blah, 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 wasting the court's time. But if she were to just have her sentence, imposed, she'd have plenty of time to get clean and stay clean.
How about, Wicca's not here, so let's get Schomer taken care of and we'll go from there.
Sounds good. I am ready when you are. I have a video pulled up ready to do a screen share too when we go. So
Okay, this is case number 25, RO07235. It is people of the city of Royal Oak versus Christine Joe Schomer. That's you, miss?
Doesn't she just ooze entitlement just looking at her?
Correct.
You're Christine Joe Schomer?
Yes.
Okay, you'll have to hold your voice up. We're making a record. Ms. Schomer, you were present earlier this afternoon when the court explained the nature of an informal hearing. True?
True.
And so you also understood the court to instruct that you must select from one of three options to protect your rights, correct?
Correct.
Thank you. Ms. Schomer, the citation before the court was issued on November 14th of this year at about 3:30 in the afternoon. You were operating a 2023 Jeep Wagoneer, black in color on Linwood, south of 12 Mile Road in the city of Royal Oak. And at that place and time, you were cited for careless driving. Officer Cherry's remarks, which appear on your citation, indicate defendant in school parking lot and exit lane. Defendant suddenly veered right, crossing double yellow lines and running over several traffic cones. That's the allegation. That is not evidence before the court at this point. You do have your three options today to protect your rights. You may admit responsibility in this matter. You can admit and explain, or you can deny responsibility. We'll swear the parties and conduct your trial forthwith. What would you like the court to do for you?
Deny responsibility.
Very well. Would you both please raise your right hands? You solemnly swear the testimony you shall give before this court shall be the truth.
yes,
Yeah.
sir.
Thank you very much. The officer has the burden. Ms. Schomer, then it's your turn. Officer Cherry.
Thank you, Magistrate. As you previously mentioned, on November 14th, about 3:27, I was parked in my patrol vehicle, which is the gray unmarked vehicle. I was parked on northbound Linwood, just south of the exit for the parking lot of Shrine Elementary School. I was there for a separate matter, looking for a hit and run suspect. While I was sitting there, I have the wonderful joy of also watching the, at times, chaotic traffic. To give you a backstory there, traffic generally enters off of 12 Mile into the lot. They either go through a pickup lane or they go into the parking lot, circle around and come on out onto Linwood. There are two, it is one exit on the Linwood, but it is broken into two directions. There is a painted double yellow line and there are cones there so that vehicles in the right lane are directed to go south on Linwood. Vehicles in the left lane are directed to go north on Linwood. While I was sitting there in my patrol vehicle, I observed a black Jeep Wagoneer that was waiting essentially in the left lane, in the left line. It had been in the parking lot, not in the drive-through lane. The vehicle suddenly accelerated, driving right over the double lines and a bunch of cones, getting several cones stuck under the vehicle. The vehicle pulled forward a few more feet and then stopped prior to exiting onto Linwood, where the driver, Ms. Schomer, exited her vehicle and then proceeded to try to get the cones on under there. I made contact with her and she told me that she sees people do it all the time. I pointed out that she was at risk driving that way for striking a kid that's not paying attention, and she told me she would never hit a kid. I also have my dash cam video pulled up. With your permission, I would like to admit that as evidence.
Sure.
I will do a screen share and we can watch the video ourselves.
Thank you.
Give me a moment. I've only done this once before.
No, we've got time. That's why we're here 5 days a week.
Let's see. There we go. Also share audio. Share.
All right, you're live.
Okay, are you able to see that?
We got that. Looks like Linwood looking north.
Okay. All right, I will stop it there unless the court requires further video, but that is the entirety of the incident.
Okay.
It was a real now you see them, now you don't kind of moment.
Thank you. Unless there's anything further, Officer Cherry, you have the right to rebuttal after Ms. Schomer's testimony. Ms. Schomer.
Yes. Okay, so I was leaving, and as he stated, there's the lane that goes right onto Linwood. I do want to make a correction. I was still in the school parking lot. Somewhere it said that he pulled me over when I was on Linwood, which I was not. I was still in the private parking lot, so I just want to make that clear. So I was in the left lane going to turn left, and I noticed that traffic had cleared on the right. So just to help with the flow of traffic, I went into that right lane. Now that double lane is for the drop-off lane. So that doesn't mean you can't cross over that double lane. It means that in the morning, that's the drop-off lane. So everybody in the parking lot has to go over that double lane in order to exit to go right. So I'm lawfully allowed to do that. So I saw that the traffic had cleared on the right, and I looked for cars, I looked for pedestrians, and there was none. Now, the traffic cones are obviously manually placed, and so I thought that I saw the last cone because the cone that I ran over, the two cones I ran over, weren't spaced appropriately to the other cone. So I had made the human error of thinking that that was the last cone that I saw when the other two cones were spaced out differently. And so that's what caused me to run over those cones. Those cones are 18 inches tall.
Which is half of the height of the average 6-year-old. Average 6-year-old is about 42 inches.
They don't pick up on cameras, but again, I am a careful driver as evidenced by my 30-year clean driving record. I did look for other cars. I did look for pedestrians. I did look for children. There was nobody in that lane. And it was a human error that I ran over that cone based on how it was spaced out.
Thank you. And what, if anything else, do you wish the court to know?
Additionally, I want the court to know that I worked 10 years as an ICU nurse, and I've worked 13 years as a neurosurgery nurse practitioner, and I've taken care of countless people that have gotten hit by cars, and I would never be careless with my vehicle in that way. I assure the court of that.
Okay. Thank you very much. And Officer Cherry, what if anything else you want to
Magistrate,
share
just
by way of rebuttal?
yes, Magistrate, just to rebut, as you could clearly see on the video, those cones showed up very clearly on my video. They were evenly spaced. They are placed there for a reason by school staff. Double yellow line, again, in and of itself indicates a do not cross type of lineage. And having cones very directly placed there, my concern again is, I understand that Ms. Schomer said that she would never intentionally hit another person. I completely have no reason to disregard that. However, that being said, she also testified that she didn't see the one cone. What if that was a toddler? What if that was another child? Those cones were there for a reason. Those lanes were designated for a reason to safely direct traffic in two ways. And as she testified, she attempted to go through that way that was very clearly coned. And as my dash camera clearly picked up all three cones, they're quite sizable. They were very, very easily visible, even from my long distance
The
away.
cones are 18 inches, which
Ms.
is
Ms. Schomer, we're not at a debate society. You were able to make your case. Officer is providing rebuttal pursuant to the Michigan Rules of Evidence and the court rules. So we're not here to simply play tit for tat. It is an informal hearing, but that doesn't mean we jump in whenever we wish. Officer, please continue.
Magistrate, I have no further to add.
Thank you very much. The court has heard the testimony of both parties.
You know, she claims that it's okay that, you know, everyone is allowed to drive. Well, if that's the case, why do they have the cones there? Methinks they wanted to stop you, crazy lady, from driving over there.
In the People versus Christine Joe Schomer, the court first wishes to indicate that since both parties are professional, they should and do understand that when the court makes its ruling, it's not inviting to debate, but will simply make its ruling, and that will be the end of the case, at least as of today. So the party does strike that. The court does believe that both parties, within their own perception of events, distances, objects, etc., appear to believe that they are proceeding in good faith. However, the burden of proof in a civil matter is a mere preponderance of the evidence. The court is confused by a few features up to and including it appeared as though there was testimony that the double line and the cones are really only for the morning drop off, and in the afternoon pickup, they're no longer needed or available or relevant. The court would wonder why they're still out there in the afternoon if that's the case. Also, the court understands that Ms. Schomer indicates she didn't see anybody, so it was okay. But seeing or not seeing a potential object or a person or even a police vehicle should not be the determining and governing factor of whether or not we are obeying the traffic signs and signals and lane markers. And for that reason, and due to the fact that the burden of proof is what it is, the court does find you responsible, Ms. Schomer. The fine for careless driving is $240. That is payable through the pay portal on the 44th District Court website, or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 7 days. If you do wish to appeal this court's ruling, you have every right to do so by posting a $240 cash bond within 7 days. The matter gets placed on the formal hearing docket. And at that juncture, the city of Royal Oak, one of two cities within this court's jurisdiction, would be represented by a city prosecutor, and that would reopen the matter up to any motion practice. So with that said, $240 is a fine or a bond within 7. That closes your case. Please always be careful.
Yeah, thank you.
That face.
would be good, yeah. If not, yeah.
Mr. Granderson? Mr. Basad?
Good morning, Judge. I'm here on the Granderson sentencing. I'm on a quick break with my hearing now, Your Honor.
Okay, well, good morning, but this is in person, counsel. Do you have permission to appear via Zoom?
I was told each sentencing was done by Zoom, Judge, because we zoomed
No,
in all the prior
no.
hearings.
Nope, on Thursdays, the only thing that's on Zoom are PCCs.
Oh, really? That's new to me, Judge, and I truly apologize. I'm
Not sure why that's new, because that's how it's been. The only sentencings that are permitted on Zoom are on Tuesdays.
So I apologize. I didn't know there was a distinction between the Tuesday and Thursday sentencings.
Okay, so how long until you're here, counsel?
Well, Judge, here's the problem. I'm literally right now as we speak. And this is no lie, Judge. I'm literally in another trial right now. So we were on a break now, with the jury, Judge. But I don't know if I can leave today and come down in person. And honestly, I didn't know there was a
Where's the
distinction.
Granderson file, please? Hold on, counsel, please. Hold on. Do you have the Granderson file right there? I believe we already adjourned it because you were in trial previously, correct, counsel?
I will. That was in a murder trial 2 weeks ago, the last time, Judge, and I'm in a jury trial today. So I do apologize.
Thank you. Counsel, do any of your notices indicate that you're appearing via Zoom?
Judge, my previous ones have, Judge, and I was on the record on Zoom, Judge. That's why I said it was never, even when I spoke to probation, I got an email one time saying that the sentencing was by Zoom. So I'm really not making that up, Judge. I'm really not.
Your email indicated that it was via Zoom. That's what you're telling me, counsel?
I said the email that I received from the probation department
Told you that this sentencing was on Zoom.
That was my
Talking to
belief,
everybody
Judge.
else. He called me, he talked to me, but when she did.
I'm sorry, somebody was speaking over you. What was that, counsel?
No, I said that was always my communications, Judge, and I'm not making that up, Judge. I'm really not.
I'm not understanding what your communication was.
That the sentencing were being held by Zoom, Your Honor.
The more he says, I'm not making it up, Your Honor, the more he says that, it reminds me of when people get pulled over and they're like, well, to tell you the truth, or if I'm being honest, it only makes you sound like you're lying.
And this was directly at the time that my client.
Hold on. You have an emergency motion to vacate conviction, so it's a motion hearing also. I do not do motion hearings via Zoom.
Judge, if you look in the file, Judge, that motion was denied. You denied that motion, Judge. And the only hearing I missed was the last one because I was in trial, and now I'm in trial again today. But that motion hearing you denied.
No, counsel, I denied the December 4th date, and I denied the emergency basis. I didn't deny the motion. We haven't done a motion hearing on it.
Judge, I submitted my motion. I got an email from the court saying that the judge denied your motion to vacate count 2. And
okay, counsel, counsel, I'm going to step off to double check and see what communication you've received, because I'm reading my notes right here. Emergency status not granted, set for hearing November 13th. Okay. Then November 13th, you sent in an emergency stipulation to adjourn pretrial, and you wanted it to be set for December 4th. The court denied that date and set it for a different date. The court has never denied your motion, counsel.
Judge, Judge, listen, I can email the court and show you exactly what the court emailed me.
Counsel, did you just tell me to listen? Is that what you just said to me?
I did not say
I just said I'm going to step off to see what communication you've received. But I do not appreciate being told to listen. So I'll be with you in just one moment.
Everyone please rise.
We're not.
You may be seated.
We'll stop. Mr. Morski, I need you to hit the join on the breakout room. Okay, it looks like she's joining now. Okay, let's go. Let's go on the record in the matter of Darius Grandison, 251089. The state of Michigan versus Darius Grandison. Counsel, your appearance for the record again, please.
And good morning, Your Honor. Attorney Kevin Basant, P71061, on behalf of Mr. Darius Grandison, who's present in court. Mr. Grandison, please state your name for the record. Darius Grandison.
Okay, so counsel, let me just go through this procedure here. You were here for a probable cause conference and you were in person on an exam on September 4th, for an exam on September 4th. It was not held, your client pled to a misdemeanor. Then this matter was scheduled for October 14th for sentencing, which I believe you were in person for. And the sentencing was not held. You adjourned it to resolve count 2, and then you were going to be submitting a motion to withdraw the plea on count 2. And the sentencing was adjourned to November 6th. November 3rd, the court received an emergency motion to vacate conviction. The court reviewed that, and the court made a note on November 3rd, emergency status not granted, set for hearing November 13th, remove sentencing from docket and adjourned to November 13th. Okay? You received an email on November 3rd. Judges reviewed and denied the emergency motion. The motion and sentencing have now been set for November 13th. So there was a miscommunication with some of the language that was sent to you. However, it also indicated that the motion and sentencing had been set for November 13th. So I denied the emergency status of your motion, but did not deny your motion, counsel. Then you had sent in a stipulated order to adjourn the pretrial. And then ultimately that was granted, but a different date. Then you were still stuck in the homicide trial. So we set it for today's date. And now here you are on Zoom for a motion hearing and a sentencing, which we are not doing via Zoom.
I understand, Your Honor, and no disrespect to you or your court judge, but Your Honor, I just got called back into this court with this trial judge. This trial was set for December 2nd. It was supposed to be over with by December 4th. Then it got moved to today. And Judge, I've had no time to let the court know in your case, but I'm not trying to disrespect you or your court, Your Honor. But Judge, I literally just got called back into my court for this trial, Your Honor.
Counsel, can you be here next Thursday, December 11th?
I will be there, Judge, with
Person for your motion hearing and your sentencing.
Thank you, Judge.
December 11th, what time, Ally? At 10 a.m. And counsel, just for future reference, please do not say, listen, Judge, okay?
Yeah.
Did he just sign off? Are we for real? Did he just sign off?
It's sentence.
Mr. Granderson, we'll see you back on December 11th. It's not your fault, sir. 10 a.m. Okay, does that work for you?
Yes.
Okay, and I do apologize that you're continuing to be here. And I'll say that sometimes some court things are outside of the control of the attorneys. Sometimes you can't guarantee or the length of a trial is sometimes out of the hands of the attorneys. So, but had you had any communication with your attorney?
Not about that, no.
Okay. All right. We'll see you back next week. Have a good day.
You too.
You can put him on our list that has to appear in person, not on Zoom for anything. We'll be here at the time of 10 a.m. Can you please send an email to Mr. Basant letting him know that the court was still speaking to him when he abruptly hung up?
I'm sorry.
Please, I'm talking to Ally.
Okay.
Okay. Who's next? Do we have the Baird file? Let's go on the record in the matter of the state of Michigan versus Paul Baird II, 25630.
Renee Cooper on behalf of Mr. Beard. Unmute yourself, sir. Give us your full name.
Paul Birdie Baird II.
Thank you.
Okay, so today was the date scheduled for a review in this matter. Your client was referred for competency June 26th of this year. The review scheduled for August 28th. The order for competency was emailed to CFP by the court on June 27th. And then August 28th, the review was held. Defendant's interview date was September 9th. We adjourned the review date to October 30th. On October 15th, we adjourned the review date to December 4th because we had not yet received the report. Yet apparently, Mr. Baird failed to appear for his evaluation.
What? No, he went to his evaluation, Judge.
Yep.
Well, here's what I have dated October 24th. Do you have something dated October 24th, counsel?
No, Judge. I just spoke with Mr. Beard when he came back from his interview. That's what I'm basing my statement on. But I
have a communication dated October 24th indicating the defendant was initially interviewed by the center on September 9th, but due to unexpected circumstances, the originally assigned forensics examiner is unable to complete this evaluation. As such, the defendant was rescheduled for evaluation to be performed by this examiner on October 22nd. However, this is to advise the court that we are unable to comply with Your Honor's order dated June 27th to perform the competency evaluation of the above referenced defendant in court case owing to the defendant's failure to present to their appointment at the time and place designated by the center, which is for October 22nd, 2025 at the Center for Forensic Psychiatry. Did you show up on October 22nd, sir?
No, Your Honor. I showed up on
So, counsel, that's what
October-
happened. Sir, you answered no. You did not show up on October 22nd. You showed up on September 9th, and I just read in the letter, you needed to have another evaluation, a rescheduled evaluation done, which was set for October 22nd. You did not show up for that.
Okay, Your Honor, I was never notified that I needed to show up in September or ever again, by anybody. So I went on September 9th. Actually, I went once before that, and they told me that I wasn't scheduled until September 9th.
Well,
So I
sir,
went back on the 9th and I did, and
Excuse
then
me.
full evaluation.
excuse
And
me,
then,
excuse me. How were you notified to be there on the September 9th date?
because when I showed up early, a week or so before September 9th, I think it was like September 4th or I don't even remember what day it was. The forensic center gave me the paper that they were mailing to my lawyer and to you guys to schedule it for the September 9th. And
Sir, let
I
me
received-
clarify. The court has nothing to do with scheduling. We are not a middleman for scheduling, not at all. The only thing we do is send the order. Mr. Cooper, did you receive notice of the date for October 22nd?
I did not, Judge.
Well, so counsel, what is it you want to do? You've requested a competency evaluation for your client's charge of possession, controlled substance, second offense notice, and he didn't show up for the October 22nd date.
Well, in more recent discussions with my client, I'm wondering whether he needs a competency examination at all at this point. He has changed significantly, and I'm sure it has to do with not using controlled substances and I suspect that's true. Am I correct, Mr. Baird?
Yeah, definitely.
Right. He's much more clear-headed, Judge, and at this point, I wouldn't think, if I got this case today, I would not ask for a competency evaluation. So, with that said, I don't think we need a competency evaluation, and I want to withdraw that request.
Okay, so did you speak to the prosecuting attorney regarding a resolution or no?
No. No, I think I should talk to Mr. Baird in a breakout room. I think we can resolve this today pretty quickly.
Okay, we'll put you back in a breakout room.
All right.
Thank you. Council, I just have Mr. Beard, and then I will get to your, the other two. We're recalling the matter of the state of Michigan versus Paul Beard, 25630. You're muted, Mr. Cooper.
I'm sorry, Judge. Renee Cooper, on behalf of Mr. Beard, give us your full name, sir.
Paul Birdie Bear II.
All
Thank
right.
you.
And so, council previously withdrew his request for competency evaluation for his client. And that was based upon Mr. Baird not being under the influence of any substances, and therefore, council believing that Mr. Baird is competent. Is that accurate, council?
That's very accurate, Judge, yes.
All right. All right, and so council, you had an opportunity to speak with the prosecuting attorney regarding this matter, correct?
I have, and I've discussed it with Mr. Beard. He wishes to waive his exam at this point.
All right, and so Mr. Baird, you do understand that you do have the right to have a preliminary examination where it must be shown that a crime is committed and probable cause exists to charge you with that crime. Do you understand that?
Yes, Your Honor.
And you also understand by waiving your right to your preliminary examination, you will be bound over to circuit court for further proceedings on the charges in the complaint and warrant, correct?
Yes, Your Honor.
And you received notice of those charges in the complaint, correct?
Yes, Your Honor.
And has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to your preliminary examination?
No, Your Honor.
Counsel, any objection to the court indicating via Zoom on both your signature line and your client's signature line?
No objection at all.
All right, the court will note examination having been waived, defendant's bound over to circuit court for further proceedings. You are to appear in circuit court on December 18th at 9 o'clock in the morning on the charges in the complaint and warrant. The court will order bond and conditions are continued. Good luck to you, sir.
Okay.
Thank you,
Your
much.
Honor.
Thank you. Have a good day.
Okay.
You too.
Right.
Entitled State of Kansas versus Pamela Sue Swan. It is case number 2025 CR 200. Pamela Swan appears in the office of her lawyer, James Watts, by Zoom. Jared Regier on behalf of the state of Kansas. This matter is set to go before the court for jury trial next week. What announcement is made at this pretrial conference, Mr. Watts?
Your Honor, I've discussed the matter with my client as well as negotiated with the state. Mr. Sweeney was actually handling this case. Jared's sitting in this morning. It's my understanding my client would plead guilty to count one of the information, possession of methamphetamine. The state would in turn dismiss the remaining counts. There's only one. At time of sentencing, Your Honor, we expect she will be presumptive probation.
Thank you, Mr. Watts. Mr. Regier, would you add anything to Mr. Watts' opening statement here?
Your Honor, the state's understanding is that at the time of sentencing pursuant to plea negotiations, the state would be recommending the mid box. I have no personal knowledge as to where this defendant may or may not fall on the grid.
Very well. Thank you, Mr. Regier. All right, Ms. Swan.
Yes. Yes.
I'm going to probably need you closer to a microphone. Your voice is faint, and I'm going to be asking you a series of questions regarding the taking of a felony plea. And if there's anything that I'm asking of you that you do not fully understand, I will give you the opportunity to confer privately with your lawyer, Mr. Watts, at any point if you need time to get further advice, okay?
Yes.
All right. Again, I will need you to speak up
Okay.
when you answer. I want to make sure all participants can hear your responses and that we get a good recording of this, okay?
Okay.
State your full legal name for the record.
Pamela Sue Swan,
How old are you right now?
49.
What's the highest level of education that you've attained?
I've done some college.
All right. Now, do you
Gotta
believe
see
you're
it
going to have
executed.
difficulty understanding any of the legal concepts that we're going to be discussing in court here this morning?
No,
Have you ever been adjudged to be mentally ill?
I do have PTSD and anxiety and stuff like that. Yes,
Do you take medication to address these concerns?
yes.
Okay. What are you currently taking?
Busprin, and I'm not sure what the anxiety one is, but the Busprin's for the PTSD and depression. So
All right, Ms. Juan, obviously those medications are meant to improve your mental health and your mental state. Would you agree?
yes,
Does the taking of these medications in any way impair your ability to understand, such as what's going on in court here today?
no,
So do you believe that you're not under the influence of alcohol or any drug right now and that your mind is clear and you have a full understanding?
yes.
All right. Did you receive a copy of your charging document in the case, Ms. Swan?
No.
Right. Do you understand
Oh,
the
yes.
nature of the charge of possession of methamphetamine?
Yes,
All right. Now, you understand that when you enter a plea of guilty, you are giving up any legal defenses that you might have had to that charge?
yes,
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses at your trial with the assistance of your lawyer, Mr. Watts, and that you could present evidence on your own behalf and subpoena your own witnesses to court?
yes,
Do you also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case, you could, at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
yes,
You understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described.
yes,
Are you also aware that you have a right to a trial by jury, that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
yes,
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
yes,
You understand, Ms. Swan, that you have a right to appeal a guilty verdict if you have a trial.
yes,
You further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after you enter such a plea.
yes,
Now, are you aware of the possible penalties that could be imposed as a result of this guilty plea that you're attempting to make?
yes,
Do you have a copy of the drug offense grid under the Kansas Sentencing Guidelines Act before you at the table?
yes,
We do, Your Honor.
If you'll look at the far right, category 5, in the 5I grid box on the drug grid, you could receive as little as a 10-month prison sentence. Do you see that?
yes,
But if you look over at the other end, in the worst criminal history category of A, you could receive up to a 42-month prison sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. We do not know with certainty at this time what your criminal history is. That will be researched by the Court Services Department, and based on the outcome of their research as of the date of sentencing, that determines where you fall along that level 5 grid line, and then you'll be sentenced accordingly. You understand that, Ms. Swan?
yes,
Ms. Swan, if you'll look at categories A, B, C, and D, they are shaded differently in some way from the rest of the line. Do you see that?
yes,
If you fall in A, B, C, or D because you have a person felony on your record at time of sentencing, you would be presumptive prison in this case. You understand that?
yes,
Okay. You also understand that you could receive up to a $100,000 fine for this offense.
yeah,
Has the concept of Senate Bill 123 been explained to you?
yes,
Senate Bill 123 is a term we use to describe the state's sponsored substance abuse treatment program. Certain persons who are in a category such as yours qualify for what is a mandatory drug treatment program subsidized by the state. You may or may not qualify for that program, but you understand that it could be a mandatory component of your sentence.
yes,
In addition to any fine that could be imposed here, Ms. Swan, Are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims if any are owed as part of your sentencing orders?
Yes.
You also understand that as a direct consequence of this plea, you'll be sentenced to an extended period of reporting probation or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes.
You understand that both probationary and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes.
You also understand that there are special sentencing rules in the Kansas Sentencing Guidelines Act. Ms. Swan, if any special rules apply to you, do you understand that it could affect your eligibility for probation or otherwise affect your sentence in some way?
Yes.
Now, have you had an ample opportunity to fully discuss legal matters like that with your attorney, James Watts, before proceeding here today?
Any questions you want to ask before we go any forward?
No. I mean,
Do you want any more time with him now to discuss things, Ms. Swan, before we go further?
yeah, just give me 1 second.
All right.
Okay. We're prepared, Your Honor.
Very well. Are you ready to go forward with this felony plea, Ms. Swan?
Yes.
All right. So are you satisfied at this point with the services and advice given to you by James Watts?
Yes.
Now, this guilty plea that you're attempting to make, has it been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No.
You understand, Ms. Swan, that if there are any plea agreements between your counsel and the county attorney's office, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. You understand that?
Yes.
So let me ask you, how do you formally plead to the charge in count 1 of the information in this case, a charge of possession of methamphetamine, a level 5 drug felony?
Guilty.
According to the state's charging document, this took place on or about April 29 of 2025. Is that when it happened?
Yes.
It happened somewhere in Butler County, Kansas, according to them. Where was it?
In Andover.
Okay. And it's alleged that you were in possession of the controlled substance methamphetamine. Where was it that you were in possession of it?
It was behind a pillar.
Behind a pillar?
Pillar. A pillar.
Okay. And where was that?
At beauty salon, I believe is where we was.
Okay. And you knew it was there?
Yes.
And you knew it was methamphetamine?
Yes. I was pretty sure of it. Yes.
Okay. Well, you're pleading guilty to it, so.
Yes. Yes.
Your Honor, I should note, so we're clear. It appears from the police report, it's alleged that Ms. Swan was seen essentially dumping this vial of methamphetamine, attempting to hide it behind this pillar, and it was revealed and found there, and she acknowledged she put it there.
All right. All right. So, Ms. Swan, do you freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for possession of methamphetamine, a level 5 drug felony?
Yes.
Mr. Regier, do you know of any legal reason why the court shouldn't accept this defendant's plea?
None from the state, Your Honor, although to supplement the record slightly, the affidavit does appear to refer to an encounter occurring in a location within Andover city limits, Butler County, Kansas.
So noted. All right. Mr. Watts, are you aware of any legal reason why the court shouldn't accept this defendant's plea?
No, Your Honor.
All right. Ms. Swan, do you know of a legal reason or any other good reason why the court shouldn't accept your plea here this morning?
No.
The court will accept the guilty plea made by defendant Swan and finds that that plea is made voluntarily. She has an understanding of the nature of the charge against her and the consequences of the plea, and a factual basis for the plea does exist. The court accepts the defendant's guilty plea, and the judges her therefore convicted of possession of methamphetamine, a level 5 drug felony. Any other charge of the charging document is dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to determine criminal history, and the court will set an appropriate date for sentencing. Ms. Swan,
Yes.
we're going to set the sentencing date out about 2 months. That
Okay.
gives court services the opportunity to research your criminal history, and you very well may be asked to do one or more assessments, a risk needs assessment and a substance abuse evaluation or assessment of some kind. You need to fully cooperate with that process and make sure those get scheduled and completed. I'm likely to hold you responsible if it doesn't get done.
Okay.
Okay. So you'll want to contact court services immediately after this hearing to get started on your pre-sentence investigation process. Mr. Watts, would you be available on Friday, December 5 at 1:15 p.m.?
Judge, I'm actually in front of you on a Dustin Fisher at 1 o'clock.
Yep.
All right.
And if it's possible, Your Honor, could we go? So that's in the height of the rifle season. I'd like to keep that evening open if we could.
All right. I can back this up perhaps with a suggestion on a different date. Do you have any commitments on Wednesday, December the 3rd at 3?
No, Your Honor, and I can do that.
Okay. Wednesday, December 3, 3 o'clock p.m. for sentencing in the Swan case. Ms. Swan,
Yes.
you must appear for that sentencing at the Butler County Judicial Center in El Dorado, Kansas. Check in with court security. They'll get you to the right location for you to participate.
Okay.
December 3 at 3 o'clock with the defendant at the Judicial Center for appearance on that date and time. All right, Mr. Regier, is there anything further from the state's perspective that we need to address?
No, Your Honor.
Mr. Watts, anything further?
No, Your Honor, I'll send her over to court services shortly after our hearing so that she can get that started.
Excellent. Ms. Swan, do you have any questions to address the court about at this time?
No.
Okay. If there's nothing further, then the Pamela Sue Swan matter will be in recess at this time. This meeting may be ended for all. Titled State of Kansas versus Pamela Sue Swan, case number 2025 CR 200. James Watts appears as defense counsel. Defendant Pamela Sue Swan appears at a court security location at the Butler County Judicial Center by Zoom. Brett Sweeney appears for the state of Kansas. This matter comes before the court at this time for sentencing. Court's docket notes indicate that the defendant pled guilty in this court on October the 10th to possession of methamphetamine, a level 5 drug felony. Sentencing was set for today. Court has received a pre-sentence investigation report compiled by Marcy Tarona's pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in this report?
No, Your Honor.
Any objection by the defense, Mr. Watts?
I've reviewed same with my client, Your Honor. We have no objection.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score I, and the court will proceed further accordingly. Mr. Watts, do you know of any legal reason why sentence should not be pronounced in this case at this time?
I do not, Your Honor.
Mr. Sweeney, are you aware of any such legal reason?
No, Your Honor.
Ms. Swan, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing today?
No.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have a motion to pursue?
We do not, Your Honor.
Does the defense, Mr. Watts?
No, Your Honor.
Are there any victims or members of a victim's family present who desires to address the court regarding the Pamela Swan sentencing? Court finds no such persons present. So at this time, the court will ask for recommendations from counsel regarding an appropriate sentence, beginning with Brett Sweeney on behalf of the state.
Thank you, Your Honor. Your Honor, pursuant to plea agreement, the state's recommending 11 months in Department of Corrections. That's the mid-box. Likewise, we would be recommending the 20% good time, 12-month post-release supervision duration. Ms. Swan has 1 day of jail time credit. She scored pursuant to the pre-sentencing evaluations as a mandatory Senate Bill 123 candidate. The state is recommending the up to 18 months of community corrections probation with all of the standard conditions that are listed within the PSI that have been prepared by Mr. Rones, including, of course, compliance with the Senate Bill 123 treatment recommendations, including any aftercare if there are any recommendations like that. As far as costs and fees go, Your Honor, the state's not requesting a fine. We are requesting the cost of the action in the matter. We're requesting $300 payable towards the treatment and evaluation, $400 for the lab report, supervision and corrections fees, first time felony, so $200 DNA fee, and then would ask the court to take a look at attorneys and bids fees as well.
Very well, thank you, Mr. Sweeney. Mr. Watts, your recommendations regarding an appropriate sentence.
Thank you, Your Honor. Pursuant to the plea agreement, the sentence recommended by the state, we would join the standard bid range 11 months with the post-release and probation duration, good time credits as noted. I don't know that I have a whole lot to add, Your Honor. This seems to be a very straightforward Senate Bill 123 matter.
How much are your fees in the representation of the client?
This would be billed to bids at $1,100, Your Honor.
What do you know about your client's financial circumstances?
Not a whole lot, Your Honor. Ms. Swan, are you working right now?
Yes, full-time at Holiday Inn in Wichita South,
And what do you make an hour?
13.
Okay. Ms. Swan, do you have dependents that you support?
No.
Okay. All right, thank you for that additional information, Mr. Watts. At this time, the court will address the defendant, Pamela Sue Swan, personally, and I'll ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court. Ms. Swan?
No, there's nothing, hon.
All right. Did you call me hun?
Sorry, Judge, there's nothing else. It's just a matter, I do it at work too.
I don't hear that in my work very often.
Well, I'm sorry.
That's why it caught my attention. All right. Court will proceed to sentencing in the case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of possession of methamphetamine, a severity level 5 drug, non-person felony in which the defendant has a criminal history score of I, thus placing her in grid box 5 drug I. Court hereby sentences the defendant to a term of 11 months in the custody of the Secretary of Corrections, the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed. Court does find that the combination of a high probability on the SASE of this defendant having a substance abuse disorder, combined with the minimum risk score on the WRNA, would indicate that this is a mandatory case for Senate Bill 123, a state-sponsored substance abuse treatment program. This defendant is ordered onto community corrections probation for up to 18 months and is ordered to successfully complete an approved substance abuse treatment program under the auspices of Senate Bill 123. Additional probation conditions will include reporting to an officer as directed, observing all laws. Ms. Swan shall not possess or consume alcohol or illegal drugs. At her supervising officer's request and at her own expense, she shall submit to random breath, blood, and urine analysis testing. She shall perform any community service work pursuant to program requirements. Notify her supervising officer of any changes in employment, residence, telephone number, or email address within 24 hours of any such change taking place. She shall maintain suitable employment throughout her probationary term, not have any contact with her co-defendant, Austin Stuber. The defendant is also ordered to abide by any curfew or travel restrictions imposed by her officer. Has she already submitted her DNA to the KBI databank? Mr. Rones nods yes. All right.
I wouldn't
The
think so.
defendant is ordered not to possess firearms or dangerous weapons, shall not associate with any disreputable characters or places, complete Senate Bill 123 treatment and any aftercare successfully, and community corrections is authorized by the court to require the defendant to meaningfully participate in the MRT program. The defendant is assessed $400 restitution to KBI, $193 docket fee, $200 DNA fee, $125 community corrections fee, $120 correctional supervision fee, $300 in Senate Bill 123 reimbursement. The court will also assess a $100 bids application fee and an additional $100 in legal fees, but waive any remainder given the bulk of the other costs that have been imposed in the case. Paid out over time, this shouldn't work hardship on the defendant.
800.
This court is inclined to require this defendant to pay at least $75 a month on these obligations, starting with the calendar month of January of 2026 and all subsequent months until her amounts are paid in full. Court notes that this defendant has 1 day accrued jail time credit to be documented on the journal entry stemming from this case. I'll advise the defendant she has the right to seek expungement of this offense at some point in the future. Certain statutory limitations do apply, however. If the defendant has any questions about her right to someday seek expungement, she can address those questions to a lawyer and I'm sure get her questions answered. The defendant, under some circumstances, has a right to appeal a conviction to an appellate court having jurisdiction. And if the defendant is unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, the defendant has 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. Ms. Swan, you do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Mr. Sweeney, I'm looking at my notes from this sentencing, and I'll ask you, are there other sentencing related matters in the Swan case that the court still needs to address?
No, Your Honor.
Mr. Watts, are you aware of anything further?
I don't believe so, Your Honor.
Ms. Swan, do you have any questions about the court sentencing orders?
No.
I'm going to go ahead and place you on an outright probation with the idea that we're going to take a rehabilitative approach rather than punishment. If you insist on punishment, though, the court can impose that later if you don't meet your probation conditions. But I'd rather see you be completely successful on your drug treatment program and your community corrections probation.
Yep.
Now, I do not have a community corrections officer on the meeting. I'm going to direct you to contact them immediately. Do you have your own vehicle today, Ms. Wong?
No, I'm on foot.
You are?
Yes.
Okay. Do you have a phone with you?
Yes.
Okay. Marcy, confirm this if you would. I think the number is 321-6303.
That's correct, Your Honor.
Okay. That's the community corrections office number. I want you to call them just as soon as we get done with court. Talk to them about your situation, that you were just sentenced on this possession of meth case and that you're with community corrections. What do you need to do next is what you need to ask the office.
Okay, and what was the last four of the digits again?
6303.
Okay.
All right, go ahead and make that call as soon as we get done here.
Yes.
Apparently that concludes our business.
Oh, C-Rex, thank you. Thank you so much. I ran through about half of what I had edited. I am going to save the other half for a little bit later. Hopefully I can get back on, but I need to go at least start trying to clear the van off before it gets too bitterly cold to even step foot out there. So I wanted to come on and spend some time with you guys and watch a few cases together. Hello, Donald Westerdale. Good to see you. I played the DeSanto clips that I watched with you this morning. So I'm gonna go work on getting the van cleared off. Take a little nap, and then hopefully be back on to see you guys before bed, okay? It won't be as late as normal because I have to get some sleep because I have that really super important lawyer meeting tomorrow. I love you guys. Thank you guys for coming and hanging out with me, and I hope to see you soon. Be safe, be well, sleep sweet, and much love. Whoops, wrong button. All right, let's try this again. Be safe, be well, sleep sweet, and much love.